Assalamualaikum warahmatullahi wabarakatuh. Today I'm going to talk about the issues in this case. The first issue in this case is whether the defendant can appeal against the decision of the learned judge of the session court which allowed the plaintiff to enter summary judgment against the defendant. The second issue in this case is whether the application for summary judgment made by the plaintiff is within the allocated time or not. Case is that previously in the Georgetown Session Court, the plaintiff claimed from the defendant the two friendly loan agreements for the sum of 500,000, both dated on 20 March of 2017, for an amount of 200,000 and 300,000 respectively. The agreed repayment dates were fixed on 28 of February 2018 and 30 June of 2017. However, the defendant failed to pay the loan, although he has been given a 4-month grace term to repay the first agreement for 200,000 and even an 11-month grace period to reimburse the second agreement for 300,000. Despite many requests and demands from the plaintiff, the defendant failed to pay the 500,000 loan in full or in part. Then, the plaintiff further stated in her affidavit that the defendant's defense are without merit and that there are no triable issues and that the defendant's defense are merely denials. The defendant is a civil engineer who teaches civil engineering and also works on modest building projects. In 2016, plaintiff and her husband invested a sum of 90,000 in two projects which defendant had undertaken the project. However, the defendant raised few grounds to be considered at this appeal. The first ground is that the reason for the delay in filing the Order 14 application not explained. Second, the claim in respect of the second agreement is premature. And third, failure by the plaintiff to rebut the defendant's assertion that he never received any money from the plaintiff. And fourth, the defendant's pleading that the agreements are subject to an oral agreement not traversed by the plaintiff. And lastly, the Order 14 ought to be used for cases where clearly there is no reasonable doubt that the plaintiff is entitled to the judgment. And the third party proceeding constitutes some other reason for the trial. Then, the plaintiff makes an application for summary judgment against the defendant on the basis of Order 14, Rule 1 of the Rules of Court 2012 and also Order 14, Rule 3 of Rules of Court 2012. The authorities used in this case is that Order 14, Rule 1 of the Rules of Court 2012 is that an application for summary judgment made by the plaintiff when a defendant has been served with a statement of claim in action to which this rule applies and the defendant has entered an appearance in the action, the plaintiff may apply to the court for judgment against the defendants on the ground that the defendant has no defense to a claim included in the writ or to a particular part of such claim or has no defense to such a claim or part thereof except as the amount of any damages. In addition, it also used the Order 14, Rule 3 of Rules of Court 2012 in the judgment for the plaintiff. Unless the court dismiss an application under Rule 1 or the defendant satisfy the court with respect to the claim or part of claim to which the application relates that there is an issue or question in dispute that should be tried or ought to be trial of the claim or part for some other reason, the court may give such judgment for the plaintiff against the defendant on the claim or part, or maybe just organs. In the case of National Company for Foreign Trade and Kayu Raya Sendian Berhad, it stated that in every application under Order 14 for the first consideration are whether the case comes within the order and whether the plaintiff has satisfied the preliminary requirements for proceeding under Order 14. For the purpose of an application under Order 14, the preliminary requirements are the defendant must have entered an appearance, and the statement of claim must have been served on the defendant, and the affidavit in support of the application must comply with the requirements of Rule 2 of the Order 14. Next, in the case of Bank Negara Malaysia and Muhammad Ismail and others, it stated that the obligation of a judge under Order 14 does not stop when one party asserts a fact and the opposing party denies or disputes an affidavit. When assertion, denial or dispute is ambiguous, lack precision or inconsistent with uncontested contemporaneous documents or other statement made by the same deponent, or is fundamentally implausible in nature, the court has a duty to reject it. So, finding the issue is untriable. And lastly, in the case of MBF Finance Berhad and Hasmat Properties Sendian Berhad, the question of inordinate delay for an Order 14 application is at the trial judge's discretion after considering the plaintiff's explanation for the lapse of time taken after the read or the statement of the defense file. It is worth noting that there is no clear prohibition in the rules of court against filing an application for summary judgment under Order 14, Rules of Court, after a defense has been filed and served. That's all from me. Thank you.
Hi, my name is Nur Alina 264773. As for the application of this case, firstly, it is clear law where the court made it clear that the application of summary judgment by plaintiff must be made through Order 14 of Rules of Court 2012. Another example is on the first issue, which is plaintiff delay in filing Order 14 application. The court referred to the MBF Finance and Hasmat Properties Sendian Berhad case, where the time lapse of 4 months and 6 days are considered as reasonable. The court also opined that ROC never prohibits the application of summary judgment to be made after a defense is filed and served. As for the second analysis, it is defendant failed to raise triable issues and plaintiff has proved a prima facie case against defendant. As an example, in the second issue, which is defendant claimed that the second agreement is premature. Plaintiff's statement of claim pleaded that the first agreement is repayable after 4 months of grace period and the second agreement is repayable after 11 months of grace period. So the court found that the second agreement is indeed not premature and defendant's contention is misleading and incorrect. Defendant also raised or pleaded the issue. Defendant also never raised or pleaded the issue in his defense. So since he never pleaded in his defense, there is no triable issue. As for the third analysis is on the importance of defense on part of defendant in his action to oppose the application for summary judgment. In the case of Ho Hang Oil, Sendian Berhad and Tang Teo Yong, the court expressed that an affidavit merely as a swear is not enough. The person affirming the affidavit must satisfy the judge that there is a reasonable ground of their allegation. Example can be seen in the fourth issue, where the defendants are pleading that the agreements are subject to oral agreement, not transfers by plaintiff. The court decided that the defendant is the one who failed to substantiate the allegation evidentially. Thus, without proof, defendant's bare allegation in his defense is insufficient. So, in conclusion, the court was right in granting plaintiff or respondent the order for summary judgment, as the defendant also failed to raise triable issues and to satisfy the court with his defense. Thank you.
This is an appeal appeal by PTPD in 2017 to impeach a default judgment made in 2014 due to its failure to enter appearance after writ of summons and statement of claim had been served. PTPD alleged that the default judgment was obtained through suppression of relevant facts. The defendant, which is Raja Khairudin in this present suit, had applied to the court to strike out the plaintiff application to impeach the default judgment under Order 18 Rule 19(1) of Rule of Court 2012. Based on this case, we had extracted three main issues, which is the first one is whether the plaintiff claim is in reality a backdoor attempt to set aside the judgment. The second one, whether the court can exercise its discretionary power in deciding the application to set aside the default judgment. The last one is whether the default judgment was obtained through the suppression of relevant facts. The Court of Appeal dismissed the plaintiff application on the ground that the plaintiff had no merits in this case. Thus, the High Court decision was upheld and reaffirmed. There are three main provisions used in this case. The first one is Order 42 Rule 13 of ROC 2012, which provide an application to set aside any judgment, including default judgment, to be made within 30 days. The second one is Order 13 Rule 8 of ROC 2012, which provide the court with the power to set aside and vary any judgment that it thinks just. The last one is Order 18 Rule 19 of the ROC 2012, which provide the court with the power to strike out or amend any pleadings or endorsement of any writ in action. In order for a party to set aside a default judgment or to enter appearance, it must first apply for leave of court. However, it is the court's discretionary power whether or not to set aside the said judgment. For example, in the case of Fira Development Sdn Bhd versus Goldwyn Sdn Bhd, the court dismissed the plaintiff application to set aside the default judgment on the ground of delay. However, in the case of Mokhtar bin Amin versus Omar bin Maziki, the court had that lapse of time is not a bar to application to set aside a default judgment. Thus, the plaintiff application to set aside default judgment in this case was upheld.
This is the case decided by the court in accordance with the law that prohibits a litigant from instituting a fresh suit to impeach a default judgment that is frequently filed after the petitioner has exhausted all appellate options or has slept on its right to set aside the decision. So the first analysis that has been extracted in this case is regarding time as the essence of the judgment. In this case, the appellant filed this present suit to the High Court of Johor Bahru to impeach the default judgment made on 2014 regarding declarations of the respondent, which are Raja Khairudin as a lawful owner of a land, or alternatively for damages of 841,000 ringgit being the purchase price and other ancillary charges incurred for the purchase of the said land at the Session Court. The judge, while giving its judgment regarding the impeachment, mentioned that the appellants cannot be given a second bite at the cherry or to have the same issues being litigated again, as it may amount to an abuse of the court process. This is because the court had applied Order 42 Rule 13 of Rules of Court 2012, wherein to set aside or vary a court order or decision, the party intended to do so must apply to the court and serve a copy of the applications on the party who obtain the order or judgment within 13 days of receiving it. And if they are running late, they may seek an extension of time to do so from the court. The judge mentions that in this case, there is still an unexplained delay of 3 years by the appellants before the fresh writ to impeach the default judgment was filed in the High Court on 7 December 2017. The court said that the appellants cannot wait for a time convenient for it to then file the separate suit to impeach the judgment of the Session Court when it had sat on its right and had not produced any facts which it had not known,
when the setting aside application was filed in the pre-session court by their previous solicitors. Therefore, upon the failure of the appellants to enter into appearance or make an application to set aside the judgment of the session court, the Court of Appeal had dismissed the ground on the basis that there is no merit that could be found in this case regarding the application to set aside the judgment or vary the decision by the session court. So the second analysis that has been extracted in this case is regarding reasonable justifications of the appellants to convince the court. So the court have the discretionary power to decide on the application to set aside default judgment based on the rules of court 2012, which is Order 30 Rule 8, whereas as the court thinks fit and just, the court may vary or set aside any judgment entered in pursuant to this order. So in the case of Vera Development Sendirian Berhad versus Corwin, this case had mentioned that the application should be submitted ASAP and within a reasonable time frame. However, in appropriate cases and as the court thinks it's fit, the court will disregard the lapse of time. So, in a situation where a party intending to apply to set aside the judgment in default beyond the 13 days period prescribed under 42 Rule 13 of ROC 2012, the applicant must provide a convincing justification for the delay. The court will then decide whether to give the defendants the extension based on a number of considerations, which may include the defendant's application delay, any irregularities in obtaining the judgment in defaults, and the case merit. If no sufficient reasons is provided and the defendant does not comply with the time restrictions and does not request for an extension, the court shall maintain the option to set aside the default judgment if another party is not prejudiced and it can be demonstrated that allowing the judgment to stand would constitute oppression. So the court in this case decided that the explanation given by the appellants was insufficient to justify the appellant's delay in filing the new claim, because if anything, the plaintiff should file a negligent claims against its previous attorney. And even though the appellant had missed the setting aside application hearing mistakenly, the appellant should have requested for an extension of time to appeal when it learned that the setting aside application had been dismissed rather than remaining silent. So it can be concluded that a strong reasonable justification is important to convince the court to set aside or vary with the judgment in default of appearance. In a conclusion, a party who wishes to set aside the default judgment and enter appearance outside the allocated time, which is 14 days after the writ of summons and statement of claim had been served to him, the person need to apply for leave of court in accordance with all the procedure that has been provided in the Rules of Court 2012. If the ground for setting aside is irregularity, then the irregularity must be specified in the application itself. A good guiding principle when dealing with the delay issues can be referred to one of the Singapore cases where the Court of Appeal has taken into consideration when exercising its discretionary power the reason for delay, length of delay, prejudice caused by the delay and merits of the case. It must be noted that the application to set aside the default judgment does not bind the court to allow the application, but it is the court discretionary power whether or not to set aside the default judgment. Thus, from this case, it can be concluded that in a litigation process, the time is an essence and the failure to comply with the allocations of time may cause the parties to lose the opportunity to obtain justice. That's all for me. Thank you.